Hello, this is Brad Berkman from Greenspoon Marder with the Ardent Spirit. We've been away for a bit, couple of weeks, perhaps, maybe just a little bit longer. Had a really couple of interesting trips. That's why we had a little bit of a delay in past podcasts. I was at the Discus Conference in Chicago, which is the Distilled Spirits Council of the United States Conference. It was a super interesting conference attended by industry members and policymakers and attorneys in the field. And a lot of really great, interesting things were discussed. Some of those issues we'll actually bring up perhaps today. We'll see how this conversation develops with our special guest, but we'll get to that in a minute. In fact, our special guest has appeared before. Some of you who have listened before will certainly recognize my special guest and partner here. Anyway, I was also in New Orleans at the Tales of the Cocktail, another super event, really extraordinary. For those listeners out there, if you ever get an opportunity to go, you really should go. It's thousands of people from around the country come to this particular event. It's really a celebration of cocktail culture, in fact. And you really get an opportunity to meet all sorts of people in the field, that is in the industry itself, including actual brand owners and producers and distributors. And professionals in the field. There were lots of attorneys and lawyers there and some regulators, I'm sure, although they may have been in disguise. I'm not certain, or incognito, which is really a strong possibility. Influencers, celebrities. It was a really great event. So if you ever get an opportunity, it's really worth attending. And of course, it's in the great city of New Orleans. So there's always, lots of fun to be had there. Here we are again today. And I did mention my special guest, or our special guest, if you will. And he's been on the show before with us. Mike Martinez is my partner here at the Hospitality, Alcohol, and Leisure Group. Mike, as you may recall, was counsel with Division of Alcoholic Beverages and Tobacco before joining our group here. He's been here with us for, of course, many, many years now. And Mike is really a super great person to talk to on virtually all things alcohol beverage law. But for me, I really enjoyed chatting with Mike about Tide House issues in particular. First, Mike, how you doing, buddy? You there?
I'm doing well. It's good to talk with you, Brad.
Mike, it's always my pleasure to talk to you. And I have to tell our listeners that although you can't see him, I can see Mike. And Mike is wearing perhaps the most colorful Hawaiian shirt I've seen. He looks fabulous, happy, tanned, and ready to engage. And I am sure what will be very interesting conversation today. So Mike, obviously, and I had an opportunity to talk about, what we're going to discuss. And it's a really interesting subject. We've talked about this issue of Tide House before, really almost ad nauseum, frankly, but we're going to discuss an interesting nuance nuance points, I should say, that really illustrate the fact that this bedrock principle of alcohol beverage law is being whittled away through exceptions in legislation, exceptions to rule, and really, market forces. Market forces play a big part, I think, in the whittling away of this concept of Tide House. And to just be really succinct, right? It's more than just Tide House. It's this three-tier system, right? We all know, and many of the listeners are aware, that beverage alcohol in the United States operates through a three-tier system. We know that we have suppliers and who are basically manufacturers or brand owners, wineries, breweries, distilleries, who sell to distributors, who then sell to retail. And then there's all sorts of, the bodies of law, federal and state, that dictate the relationship among those three tiers. Over the many years since the inception of Tide House, hey, Mike, let me ask you this. How far back do you think this concept of Tide House actually goes? Where historically speaking, do you think that this notion first developed? Any idea?
I believe it goes all the way back to England, and they had pubs that were directly tied to specific manufacturers. And that's the origin of the the connection, the tie between the retailer and the manufacturer. As far as like United States regulations, I believe it was a post prohibition repeal when they really enacted the Tied House framework.
Right. And I think that, and the whole point, of course, and I'm sure Mike would agree with me, was to cut that tie, right, between manufacturers and retailers. And, what developed literally post-prohibition with the repeal of prohibition was the bodies of law, again, that created the structure for the relationship amongst the various tiers in the industry. But again, we're going to talk about the exceptions over time that have whittled away at this concept of Tied House. It's sort of almost like a regrafting, if you will, of the relationship between the manufacturer and a retailer, and in some instances a distributor. That is sort of creating that tie that that Tied House was supposed to do away with. And I'll point you to manufacturers specifically. Right. So let's take a look at what we call, let's take a look at manufacturers here in the state of Florida specifically, and let's limit this conversation really, I think, Mike, to Florida specifically. So in Florida, at a producer level, we basically have, wineries, we have distilleries, and we have breweries. And each one of those holds its own specific license type. A brewery, as an example, will hold what's called a CMB, and a distillery will hold a DD as an example, and wineries hold similar licenses as well that allow them to operate as manufacturers, producing their various products, right? Distilleries produce distilled spirits, breweries produce their beers, and wineries produce their wines. Traditionally, these producers, these manufacturers were required to produce and sell to Florida licensed distributors only. But over the many years, exceptions were written into the law and into the code that allowed these manufacturers to, in fact, function in certain instances with lots of requirements as retailers of alcoholic beverages, and in some instances as distributors of alcoholic beverages. So let's just talk about, as an example, breweries. Let's start with breweries. So a brewer holds, again, what's called the CMB license, and that allows them to operate as a brewery and manufacture and make beer. Buried in the statute, and I think Mike will probably agree with me, but Mike probably has a bit more of an understanding of the historical context of this, and so we'll turn to him in a second on that. But buried in the law really was this notion that breweries in this state were permitted to actually sell beers that they produced on their premises and allow them to sell to consumers on their premises, in all practicalities, turning them into a retailer. The way the law was written, in fact, was that they were allowed and permitted to hold both a manufacturer's license and a retailer license that allowed them to sell directly to consumers. Mike, why don't you do you have an understanding of the historical context of that? I know it was for a very long time referred to as the Busch Gardens statute that sort of opened the door to this concept. Why don't you tell us a little bit about that, if you could?
Sure. I agree. In my perception, what happens is, you have an original entity that is very well represented with lobbyists. They get an exception crafted somewhat narrowly to fit their physical characteristics. And then that operates for some unknown number of years until some creative person comes along and really sort of blows it wide open. And I certainly believe that it was the Busch Gardens exception. That's when I started with the state. That was what we traditionally referred to it as and knew of it as. And there wasn't really, to my knowledge, anyone else who had looked into this exemption. And obviously, with the advent of craft breweries, this exception has really exploded to create a number of smaller breweries, and some which have grown and been absorbed. And I know you know a lot about that, but ultimately, this exception has really expanded a great deal. And it did start out, I believe, as Busch Gardens and has grown exponentially. When I was with the state, we had some people that came forward and they had a retail license and they wanted to take advantage of this exception, but you have to be a manufacturer first.
Right.
And at the time, we thought, well, this doesn't really fit within the regulatory scheme, but how big could this possibly get, you know?
Yeah. So let me ask you this. So the retail license, generally, our listeners will probably, when they think about this scenario, they'll probably think of tasting room, right? So when they go to their favorite brewery here in South Florida or anywhere in Florida for that matter, they have this notion that they're going into a tasting room and they're going to taste the beers that are produced on the premises. In fact, it's a lot more than just a tasting room, right, Mike? It's actually a separate portion of the premises that's licensed as a retailer, and separate and apart from the manufacturing premises. And what kind of licenses, Mike, can these retailers hold? Or the retail portion of the brewing premises hold?
To my knowledge, there's no restriction on the type of license that can be held. We certainly have worked with people of all different manners, restaurant licenses. Some individuals will have quota licenses, although that's less common. Many venues will have a beer wine license because it fits within the concept and it's regulatorily more easily obtained. So yeah, it's definitely, as we go through the exemptions, it's interesting to see how they were crafted over time to allow for different concepts within the different manufacturing tiers. But in this case, they can and must obtain a license in order to sell products.
Right. So what's great for our craft breweries, particularly for the products that they produce on the premises, is that they can actually transfer the product from the licensed brewing premises to their retail premises via any sort of mechanism, right? For a bright tank or directly into the tap handles, or I mean, there's all kinds of ways they can do it. And you can literally, drink freshly brewed beer on the retail licensed premises that's been produced on the manufacturer's premises. All other products, other wines, other beers, and in some instances, distilled spirits, particularly if they hold a quota license or an SFS, which is a restaurant license, a food service license, where do they have to buy those products from, Mike?
So all those products are going to go through the normal distribution channels. And I think that's something that people might not realize, that these while they are manufacturers, their licensed premises, as you've discussed, their retail location, are generally subject to the same restrictions that other licensees would have, retail licensees would have in regards to obtaining products from distributors. They are allowed to transfer. If they have more than one location, they can transfer some of the product that they produced at another location, but only up to the amount that they are brewing at the receiving facility.
Right. Interesting and a good point. That's a great point. Let's turn it on its head for 1 second, though. So we're focusing on exceptions, and the exceptions are that a licensed manufacturer can hold a retailer license, right? So this is an exception to Tied House that prevents manufacturers from being retailers. That's the whole point of this conversation, right? So pointing out certain exceptions in the law that have sort of are, I don't want to say violating, obviously they're not violating, they're permissible, but are contrary to our general understanding of what Tied House actually is. So Mike and I were talking actually before this, and when we look at exceptions, we think about, here's an important point actually, but when we think about exceptions, I think about exceptions particularly from, manufacturers being granted exceptions to act as a retailer. So it's, again, granted to the manufacturing entity. An important point to think about and to keep in mind for those of you listeners who might be considering opening up a brewery or a winery of some sort is that once you qualify under this exception, you qualify going forward as a manufacturer regardless. So you will be precluded from going forward from holding a purely retail alcohol beverage license at a different venue. As an example, you can't open a nightclub and have a quota. That will qualify you as a retail licensee or a vendor licensee, absent some creative structuring, but generally it's impermissible under the law. So you first qualify as a manufacturer, and have to go forward at that level and in compliance with the rules and regulations of the laws that govern manufacturing. But let's turn the exception on its head for 1 second. So let's talk about another little creature that we have here in Florida called the CMBA, right? Brew pub concept, Mike. So this is an interesting exception. In fact, this is an exception that's not granted to the manufacturer, but it's an exception that's granted to the retailer. Why don't you tell us a little bit about that, Mike? Why is this an exception? What's different about the CMBA versus the CMB, right? The retail exception versus the manufacturer's exception.
Yeah. So the CMBP, the brew pub
CMBP,
exemption.
I'm sorry, I called it CMB.
So that is interesting in the sense that the retailer, effectively, you have to look at what the primary licensure status is. And as a technical matter on it, you are a retailer who also happens to brew at your premises. So it's not even a separate manufacturing license. It's a modifier on the retail license, which allows you to brew.
Right.
So it really is very different. And it's much more restrictive in the sense that you cannot sell anything you make to a distributor.
Right.
So there is no way to truly grow your brand out of that scenario unless you were to close down your retail venue and shift the concept over to a manufacturing venue. But it is truly the flip side of the coin in the sense that you are a retailer that has the ability to manufacture and sell for consumption on the premises your product.
Right. Really interesting. And just for a little clarification or edification of the listener, there is a limit on the number of kegs that you can produce a year, right, Mike?
Yes, it is capped.
Right. It's capped at, I think, about 10,000 kegs a year.
10,000 kegs. It seems like an awful lot of product, though, Brad.
It is. I would agree with you. It's 15.5 gallons a keg. That's a lot of product. But you know what? I mean, I would suspect there are probably, well, I don't know. There are probably some CMBP holders out there that are doing it. I have to say, the reason why I had CBMA on my mind when I said CBM, when I referred to the craft brewer's license as with the A on it. Totally unrelated. That's the Craft Beverage Modernization Act and issues of taxation. Maybe we'll talk about that another time. Let's jump over to, since we're talking about breweries, let's just talk about the distributor exception for 1 second, and then we'll jump into distilleries very quickly. So here's another interesting little exception that exists. That is an exception to Tide House specifically. Generally, beverage law prohibits manufacturers from being distributors of their own alcoholic beverage products, right? There are a few exceptions in our beverage law. Let's talk about Florida that do allow manufacturers to distribute their own goods. And I can think of 2 instances where that's permitted, and I know Mike can too. I'm going to defer to Mike and ask him to tell us just a little bit about the exception that exists, particularly in Florida Statute 563022. Our dear friend, known as the relations between beer distributors and manufacturers. Why don't you tell us a little bit about that, Mike?
Yeah, that is a very interesting exception, and I think it may have originally been envisioned as a situation in which a manufacturer could not find somebody to distribute in remote areas. They could have a limited partnership arrangement and for a specific period of time, and it's limited to 8 years. And so that you could fill in the gap if there was a problem with service. And while I was with the state, we got involved in some litigation, and it turned out that a extremely large manufacturer in Miami-Dade County was apparently unable to locate a distributor, which was somewhat surprising to us, and had a limited partnership arrangement, such that they were also involved as the distributor of their own product.
Right.
And that is no longer the existing structure, but at the time it was a real eye opener. And I think
for that particular company you're thinking of, it's no longer
right. And it really highlights something, and that is there's so many of these relationships or these exceptions and these structures are are opaque and very convoluted, and the regulators do not necessarily have a grasp of what is really occurring in the real world, so to speak. That one definitely, like I said, wasn't unlawful. There wasn't anything improper, and it had been structured correctly, and everything was above board. But it certainly, it could be argued of whether or not it fit within the spirit of the law, but it certainly was not. It was not, illegal or anything of that nature. So, but it's a limited exception to some
Right.
extent.
It is a limited exception. It's only, you can only exist for, I think, a period of no longer than 8 years. And it's got to be formed as a limited partnership exclusively. That is, I believe, the manufacturer would be the limited partner in the partnership with the distributor, if I've got that correct. I think I do, in fact. So it is interesting, but it's an interesting exception as well that exists in the beverage law, right? So now we've addressed the manufacturer retailer exception. We have addressed manufacturer distributor exception, particularly as it relates to malt beverage products. Let's jump over to our friend, the distilled spirits plant, and talk a little bit about how the exceptions exist for producers of distilled spirits. And, it's very different. It's not let me just backtrack for 1 second and say this. We sort of skipped over wineries, Florida wineries, but wineries have similar exceptions. And I say this in a general way to breweries. Okay, these as CMBs and CMBPs as an example, those exceptions do exist with their own nuances for wineries. But for the purposes of time, we'll just simply say that they are fairly similar to the winery exceptions are fairly similar to the brewing exceptions. But I think it might be a little more interesting for the purposes of this conversation to now talk a little bit about, again, distilleries and what exists there. And here in Florida, in particular, distilleries obviously qualify as a manufacturer, not dissimilar, again, to the wineries and the breweries, as we discussed. So they hold a manufacturing license. There are two kinds available. There is a full production distillery, which holds what we call a DD license, or DABT, or DBPR calls a DD license in the state. For those of you who didn't get the acronyms there, let me just add that DBPR is a division of business and professional regulations, and DABT is a department, and DABT is the Division of Alcoholic Beverages and Tobacco, the regulatory body that oversees alcohol and tobacco in the state of Florida. The DD license, the distiller's license, is a full-fledged distillery that really is not granted any special exceptions under Florida beverage law. The CD, or craft distillery, is a unique animal in this state and differs significantly from the exceptions granted to brewers and wineries. Mike, why don't you jump in here and tell us a little bit about why these exceptions are so unique? What's the difference between, let's say, the brewery and distillery operator?
To me, some of this is tied historically. So the winery exception was the original one in 1963. Then you have the brewery exception, the Busch Gardens exception, and then you have the explosion in the early 2000s of the craft breweries. And I think what happened was the distribution tier, the distributors realized that the loosening of Tied House was accelerating, and the change. And once you took the genie out of the bottle, that it was very difficult to put it back. And there were deals cut to get exemptions, and that this would be all they ever went for. And then every year they would come back for more and more and more. So in my perception, when the distillers came forward and made a lot of the same arguments that the breweries had made, that the lobbying effort was much more advanced and prepared to do battle on these issues and to hold them off as a practical matter.
That's so interesting, really.
Yeah. So they also, and so it was crafted in a very, very different way, in the sense that a distillery is the only entity ever created, to my knowledge, in the history of the beverage law, which could sell alcohol without having a retail license.
Fascinating, really.
Yeah, so they're the only ones. Originally, they were allowed to have these,
So what does that, tell us what that means. Tell us how do they go about selling without a license?
Well, they were allowed to have a room either on or adjacent to their premises where they were allowed to sell very specific amounts of their own product,
Right.
no other product. It started out very narrow, limited amounts, only if they were a craft distillery. So there were production limitations that were put in place.
Right.
And they really just sort of the getting the camel's nose through, they started out with very, very restrictive. And I think the concept by the industry was to not let them obtain a retail license. That tends to expand or weaken the tight house structure, which of course, if you're a distributor and you have a monopoly, you are loath to have it undermined. So I think that was the origin of those issues.
Sure.
And over time,
let me just jump in, just draw a distinction. I think it might be important to the listener. And the difference between a distillery and a craft distillery is the amount produced. And again, just for general information, a craft distillery defined is a distillery in the state which distills, rectifies, or blends. Distills, rectifies, or blends 250 gallons or less of distilled spirits. So that's the number. That's the cutoff, right, Mike? If it's 250,
well, 1,000.
What did I say? 250,000 gallons, correct?
Right.
250 gallons?
Yeah, that's what you
forgive me. Right. It's 250,000 gallons, clearly.
Right.
Right.
Now, but again, that is a lobbying effort to increase the requirement because it was a smaller amount and then larger and larger. So that's the way these things tend to go, is to loosen the binds of tight house at every session, or the attempt is always made.
So here's the interesting thing too, right? So there's a limit so without this retail license, they're permitted in their tasting room to sell product directly to consumers in face-to-face transactions, right? So there's a limit as to the number of gallons that can be sold there, right? Isn't that right? I think it's 75,000 gallons of product produced.
Right. So there's a limitation now on the total amount. It used to be 6 bottles per patron per year. And that has increased to thousands of gallons. So it is a very, that is just further sort of clarification of the expansion of this exemption.
Sure. What else can they do with that though, Mike? Not only can they sell bottles, but what else are they permitted to do now?
Now it is expanded to where they can also serve drinks on the premises. They can, and I don't know if you're going to touch on a further option where now, in a very limited nature, they can obtain certain craft distilleries can obtain a retail license, but it's a very, very tight window.
I'm going to let you talk about that 1 second. The really interesting thing is that now craft distilleries can have tasting rooms that in essence function to a very large degree as bars without holding any retail alcohol beverage license. So the super interesting thing, going back to our brewing exception and winery exception, is that, in order to be able to sell it directly to consumers, you have to hold a retail license. Here, in the distillery scenario, you're not permitted to hold a retail license, but the way the statute is crafted and drafted, you are permitted to make sales directly off the craft distiller's license to consumers as if you are operating as a retail or vendor licensee. So it's another super interesting exception. But Mike pointed out that there is a unique provision in the craft distillery statute that allows for certain types of distilleries to hold quota licenses. Mike, jump in, tell us.
So the destination entertainment venue craft distillery, which is a very specific set of limitations, arguably crafted for one venue. It's got to be within a redevelopment area under a community development plan. It has to be a craft distillery. It's got to be adjacent to modal transportation options, minimally bicycle, pedestrian trails. So and it has to have an area of at least 15 acres and have an indoor event. So obviously there is a location which has a very impressive lobbyist which got this exemption put in. But it seems there may have been a bit of horse trading in the sense that there were some other limitations that were added in at the time of this passage But the other thing is that for distilleries, there is no distribution exception, as we mentioned, for breweries,
Right.
and there is for the wineries. So they have gotten part of the way that they were trying to get to in a limited retail, very, very limited retail option, as far as having a license, not as making sales, however, but it is evolving, but they have not been able to crack the distribution exception as of yet.
Right. Very, very interesting. Well, yeah, I think that's going to be a long time coming, but we can discuss that another time, I think. There's all sorts of very other interesting areas where we're seeing exceptions. I think we highlighted today some of the more interesting ones, particularly looking at exceptions for manufacturers and again, the reverse of that in the form of the CMBP for retailers being granted the exception to act as a manufacturer. Mike, we're going to have you back on here and we're going to discuss a completely different topic that's changing the face of our industry and that is also whittling away in a most significant way at the three-tier system and Tide House. We're talking about direct to consumer sales from producers using websites and the internet and how that works. There's lots of interesting models out there. The listeners can't see, but Mike is nodding his head. I can see him. He's nodding his head. I know that he finds this topic very interesting. He and I have worked on lots of projects together representing numerous participants in that distribution chain, if you will. That is the manufacturer, the advertising website, retailers, they're involved as well. There are all kinds of different models, but it behaves contrary, if you will, operationally from the traditional three-tier system. But we're going to talk about that another time for another conversation. I'm just going to turn to Mike and ask him if he's got anything additional that he'd like to say to wrap up this podcast, and then I will say my goodbyes. Mike, anything you'd like to add before we sign off?
No, this was a great discussion. I look forward to our conversations regarding the direct shipping of product. That is fascinating, so many from a regulatory perspective, and I appreciate being asked on and look forward to working with you on this in the future.
Well, it's going to be a lot of fun. We always have a lot of fun. It's interesting stuff. And what the listeners are not privy to is the debates and the arguments and the discussions that precede these podcasts. Anyway, we appreciate you listening. Until then, I like to sign off with cheers. That is cheers in a language other than English. So today we're going to go with kanpai, which is Japanese for cheers, or which is apparently literally translated as dry cup or empty the glass. So for all you listeners of the Ardent Spirit, kanpai, and we will see you next time. Thank you.